welcome to another episode of Quotes This Week presented by LiveLaw. This is your host, Ostika Das. In this episode, we are going to talk about what the Uttarakhand High Court had to say about the communal tension in Uttarkashi's Purola town, the latest legal development with respect to the fresh wave of violence in Manipur, whether bike taxi aggregators are permitted to operate in Delhi, Kerala High Court's decision with regard to the enrollment fee for prospective advocates, and more. Let's begin. Purola town in Uttarakhand has witnessed an uptick in communal tensions over the last few weeks over the attempted kidnapping of a 14-year-old girl by two men, one of whom was a Muslim and the other Hindu. Both men were promptly arrested by the police, but this provoked an unabated communal frenzy in this quaint hill town, which eventually spread to neighboring areas. Reports and disturbing visuals reveal that right-wing outfits held protests in several areas and attacked the shops and houses of Muslims in Purola and threatened Muslim traders with dire consequences if they did not vacate their shops. Hindu right-wing groups had also announced that a Mahapanchayat would be held this Thursday. Several people and organizations wrote to the Chief Justice of India expressing apprehensions that this proposed Mahapanchayat would lead to an outbreak of communal violence in the area. A petition was also filed by one Association of Protection of Civil Rights. However, a vacation bench of the top court refused to entertain this petition and directed the NGO to approach the Uttarakhand High Court. On the very next day, which was the same day on which the Mahapanchayat was supposed to be held, the High Court heard the matter. The Advocate General informed the bench that the scheduled congregation of Hindu right-wing parties had been called off after the state intervened and the situation was diffused to that extent. While recording the statement, the bench directed the state to fulfill its constitutional obligations of A. Maintaining law and order, and B. Ensuring that there is no loss of life or property. The bench, comprising Chief Justice Vipin Sanghi and Rakesh Thapliyal, however, refused to direct the police to register FIRs against the people who had issued ultimatums to Muslims in the area to leave their homes and businesses. The bench said that it was for the police to decide whether any cognizable offence had taken place, and to address any grievances with respect to this decision of the police, the magistrate could be approached under section 156(3) of the Code of Criminal Procedure. Interestingly, the bench also directed the petitioner, its associates, and all others concerned to refrain from social media debates on the issue in order to normalize the situation. Chief Justice Sanghi orally observed, and I quote, "We would not like a flare-up on social media with allegations and counter-allegations, or debates on television or social media." The state of Manipur has been witnessing a fresh wave of violence over a High Court order to consider granting scheduled tribe status to the majority Metis community in the state. The large-scale violent clashes which the state is struggling to contain has broken out along ethnic fault lines between the tribal Naga and Kuki groups and the non-tribal Metis community. Since the outbreak of violence in the beginning of May, several petitions have been filed before the Supreme Court, including one by the Manipur Tribal Forum Delhi, seeking a probe by a special investigation team into the violence as well as compensation for the victims, a petition challenging the direction of the Manipur High Court, and a plea challenging the internet ban imposed in the state since 3rd May. Now, the Manipur Tribal Forum has filed a fresh interlocutory application stating that the court ought not to rely on what they say are empty assurances made by the Union of India. The organization has accused the union government, together with the state government and the chief minister, of jointly embarking on a communal agenda for the ethnic cleansing of the Kukis, saying that the tribal Kuki group is being ethnically cleansed by an armed communal organization. The application has prayed for the protection of the tribe by the Indian Army. The forum has prayed for directions to be passed to the Indian Army to take full control of the law and order and public order situation in the violence-hit districts of Manipur. The Supreme Court has held that the theft of personal belongings of a passenger is not a deficiency of service by the Indian Railways. Accordingly, a bench comprising Justices Vikram Nath and Asanuddin Amanullah set aside orders passed by Consumer Forum whereby Railways was directed to reimburse the stolen amount of cash to the passenger. The bench held, and I quote, "We fail to understand as how the theft could be said to be in any way a deficiency in service by the Railways. If the passenger is not able to protect his own belongings, the Railways cannot be held responsible." Supreme Court Judge K.M. Joseph retired on June 16th, but not before pronouncing two verdicts one day before his superannuation. Notably, one of the judgments has, in a significant development, held that the Competition Act 2002 would be applicable to Coal India Limited despite it being a public sector undertaking. The bench was hearing petitions by Coal India contending that since it operated coal mines covered under the Coal Mines Nationalisation Act of 1973, it would not come under the Competition Act. This plea was opposed by the Competition Commission of India. While remanding the matter back to the Competition Commission for deciding the issue on merits, the Supreme Court also observed that state monopolies, government companies and public sector units cannot be allowed to indulge in anti-competitive practices in violation of the Competition Act 2002. It has been held that Coal India answers to the description of an enterprise being a legal person engaged in an activity relating to the production, storage, supply, distribution and control of goods. It must be noted that the only activity of the government which has been excluded from the scope of section 2H and therefore the definition of the word enterprise is any activity relatable to the sovereign functions of the government. The judgment noted that as per section 19(4), the Competition Commission, while inquiring into the dominant position of an enterprise, should also take into account whether a monopoly or a dominant position acquired was as a result of any statute or by virtue of being a government company or a public sector undertaking or otherwise. Referring to the language of this section, the court observed, and I quote, "This is a clear indication that far from excluding governmental bodies like a governmental company, a public sector undertaking or a body under a statute from the purview of the Act. The lawgiver has evinced its intention to include government companies, public sector companies and bodies acquired under a statute within the ambit of the Act." In an important development, the Supreme Court has stayed the order of the Delhi High Court allowing bike taxi aggregators like Rapido and Uber to operate bike taxis without aggregator licenses in Delhi till the Delhi government notified its policy for the same. The controversy is over a public notice issued by the Delhi government in February, which in a sense prohibited the use of two-wheelers by aggregators. The government said that two-wheelers were being utilized by the aggregators without proper license or permit. This notice was challenged by aggregators like Rapido and Uber before the Delhi High Court, invoking its writ jurisdiction. While the matter was pending, the Delhi government issued show-cause notices to the aggregators contemplating coercive action. The Delhi High Court in May passed an order staying the impugned notice and directing that no coercive action would be taken against bike taxi aggregators till a final policy has been notified by the government. However, the Supreme Court has lifted this stay, noting that a stay on the whole-scale operation of a statutory regime till finalization of policy was unwarranted. In a small relief to the bike taxi aggregators, the bench recorded the Delhi government's statement that the concerned policy would be in place and the licensing regime would be operational by 31st July 2023. Notably, during the hearing, the top court also indicated its dissatisfaction with respect to the insurance coverage that the Motor Vehicle Aggregator Guidelines 2020 provide for drivers as well as pillion riders. You may remember that earlier this year, in February, a single judge bench of the Kerala High Court had passed an interim order barring the State Bar Council from collecting more than 750 rupees as enrollment fee for enrolling prospective advocates. This direction was challenged by the Kerala Bar Council. Last month, even the Chief Justice of India expressed concerns about the prohibitively expensive enrollment fees charged by state bar councils while hearing a PIL against them. Section 24(1)(e) of the Advocates Act 1961 specifically lays down that law graduates should be charged ₹600 for enrollment as advocates. The argument offered by the President of the Bar Council of India that this amount did not account for subsequent inflation did not find favour with the Apex Court bench, which pointed out that there was no provision which allowed for the sum to be adjusted based on annual inflation. The Supreme Court not only directed the state bar councils to file their responses, but also asked them to reveal in an affidavit the amount that they had collected in a year. In the meantime, the Bar Council of India convened a meeting of all state bar councils on the direction of the Supreme Court for fixing a uniform fee for enrollment across India. Now, in the latest development, a division bench of the Kerala High Court has refused to set aside the order of the single judge while hearing the State Bar Council's appeal, and directed the regulatory body to collect not more than ₹750 from applicants wishing to enroll, till the time that the Bar Council of India finally decides on the issue of a uniform fee structure. A sessions court in Mumbai acquitted 2 accused in the second part of the 2002 Best Bakery case in Gujarat. The 2 accused, one Harshad Solanki and one Mafat Gohil, were absconding when the other accused in the Communal riots case faced trial in Mumbai, leading to a separate trial for these 2. For those who are unaware, after the Godhra train burning, a Muslim-owned bakery called Best Bakery in Vadodara was burned down by a mob on March 1, 2002. This horrific incident claimed the lives of 14 people. While acquitting Solanki and Gohil, the court said that the prosecution had failed to prove their role in the attack on Best Bakery, and mere presence in a mob without any role in the violence would not make the accused liable for conviction. Another related development is that another sessions court in Gujarat acquitted all 35 surviving accused in 4 cases in connection with the 2002 post-Godhra riots case. In these cases, 52 persons were initially charge-sheeted under various sections of the Indian Penal Code and Bombay Police Act. Out of these, 17 died during the pendency of the trial, which went on for 20 long years. In its order, the Court of Additional Sessions Judge Harsh Balkrishna Trivedi noted that in this case, the police implicated prominent Hindus of the concerned area, including doctors, professors, teachers, businessmen, panchayat officials, etc. The judge also lamented that due to the uproar of what he claimed were pseudo-secular media and organizations, the accused persons had to unnecessarily face prolonged trial. Going further, the court also observed that prosecutors who are afraid of specific community-led NGOs rarely have any recourse. A special court in Bengaluru has rejected a private complaint filed against Karnataka Chief Minister Siddaramaiah under sections 499 and 500 of the Indian Penal Code. The complainants state that they belong to the Lingayat community, and when Siddaramaiah was in the opposition, he allegedly made a derogatory and defamatory statement against the community in front of the media during the 2023 election campaign. Under the scanner was a statement made by the Chief Minister claiming that his predecessor had spoiled the state due to their corrupt nature. When asked by a reporter about BJP's strategy to field a Lingayat candidate for the position of Chief Minister, the complainant argued that this disparaged the reputation and moral value of the entire Lingayat community. However, the special court disagreed. After watching the video footage of the statement in open court, the magistrate held that Chief Minister Siddaramaiah had made no imputation against the entire Lingayat community, had only referred to the Chief Minister who came before him. We have come to the end of this episode. Courts This Week is a special segment where we bring to you the most pertinent legal developments that took place last week from across the country. If you found our compilation useful, don't forget to like, share and subscribe. Drop us a comment below with your suggestions and feedback and tell us what you thought of this week's developments. Also, hit the bell icon on YouTube to get a notification whenever we upload another episode, and visit our website www.livelaw.in to read our detailed reports. This is your host, Ostika, and I will catch you again next time.